You might remember that I did a video about Nigel Farage to say that he might have been at risk of a lawsuit because he used the words that they were being very, very dishonest. But then, of course, since then, he published the full document of many tens of pages to prove that what he was saying was right. And then since then, he's had an apology from the BBC, and the CEO of Natwest has stepped down with an apology of sorts contained within the statement released by the bank on stepping down. But it doesn't end there, because some of you will now think, well, what about Nigel? Can he not have a case against the bank? And some of you, I know, have mentioned this in the comments, so this is in response to some of you that have mentioned that in the comments. And so my response to that is, yes, there is a potential case for Nigel Farage against the bank, and on a number of different bases. First of all, there is quite a clear, in my view, not that this is legal advice, Mr. Farage, if you're watching this, but in my view, a clear breach of GDPR here. And I'll go on to explain why, because some people might say, well, everyone knew who Nigel Farage banked with. Well, first of all, everybody didn't know, but even if they did, and that information was quote unquote in the public domain, that doesn't necessarily matter, for reasons I'll explain in a moment. Secondly, it's considered to be a breach of confidence, because whether it's with your bank or with a lawyer or with a doctor or anybody else, there is a necessary quality of confidence about the relationship between you, the exchange of information, the conversations, the details, and so on. And I could go on for 3 hours explaining what that is. But in essence, they should have kept it confidential. So a bank should always keep its clients' information and activities, and even the mere fact that they bank with them. So there is a clear breach of confidence there again, which in my view on reading the statement by Alison Rose is quite clear, but I'll come back to that statement in a moment. There is also potentially the misuse of personal information. And so there's a whole set of damages to talk about that. But instead of go on too many things in this video, I will direct you to the Art of Law channel that I co-host with Alan Robertshaw. He's doing a video on that today, I believe, which I will link as soon as it's ready in the description, and I will pin it as a comment below. But first of all, turning to this statement by Alison Rose, stepping down as CEO of NatWest Group. The statement says she recognises that in the conversations with Simon Jack of the BBC, I made a serious error of judgment in discussing Mr. Farage's relationship with the bank. Given the consequences of this, I want to address the questions that I've seen raised and set out the substance of the conversations that took place. Now, here's the next bit that I think is again, I think with all respect, I think is another error of judgment in even including this in the statement, although I suspect lawyers would have had a look over this, and this is probably the best of a bad situation for them to what to include in this statement. The next bit says, believing it was public knowledge, I confirmed that Mr. Farage was a Coutts customer and that it had been offered a NatWest bank account. Alongside this, I repeated what Mr. Farage had already stated, that the bank saw this as a commercial decision. I would like to emphasise that in responding to Mr. Jack's questions, the BBC journalist, I did not reveal any personal financial information about Mr. Farage. In response to a general question about eligibility criteria required to bank with Coutts and NatWest, I said that guidance on both was publicly available on the websites, and in doing so I recognised that I left Mr. Jack with the impression that the decision to close Mr. Farage's accounts was solely a commercial one. So in essence, and by extension and by inference, even she acknowledges that Mr. Jack was left with that understanding that his accounts closure was a commercial decision. So even if you don't expressly say a thing, it doesn't necessarily mean that you've not shared information, because even in saying and not saying and the bits that you leave out, it's a bit like jazz in that sense, in that some bits that are left out actually make the piece. So in this sense, what was said and not said have left Mr. Jack with that understanding. But going back to the beginning of that paragraph, believing it was public knowledge. Now, this is in some sense referred to as the public domain, and it comes back to the point that I made earlier when somebody said, well, what if everybody knew and this information was in the public domain? Well, the public domain is not really a thing. It's thought of generally as being what can be found online or on the internet or in the media, and has no general cost of access, as in everybody can look it up, everybody can find it. So for example, the old telephone directories, or now what is on Twitter, which for those that don't have their tweets protected, or X's protected, as Elon Musk now insists that we call them, those are what people think of to be in the public domain. However, as far as GDPR is concerned, it's not that simple, because GDPR, in a very broad sense, protects your personal information, and it gives you all of the rights under the data protection legislation: the right of access, the right to be informed when it's collected and shared and processed, and all of this sort of thing. And so information should not be shared unless it's a very, very narrow, legitimate reason, or with your consent. So the processing of your data, which includes sharing it, should not happen unless there is a legitimate interest, a legal or lawful reason, or with your consent. So for example, if there's a crime and they send it to the police, that's one thing. If they ask you within terms and conditions that they need to share it with somebody else, that's another, and you've provided consent. But in this specific case here, for the avoidance of doubt, sharing it with a journalist is not one of those legitimate interest type scenarios. So without consent, that shouldn't have happened. But the question remains is, what about it being linked to the public domain? Well, as far as GDPR is concerned, anything in the public domain is not fair game. Meaning you can't just go and collect that information and store it on a database just because it's in the public domain. And also, just because it's in the public domain, it doesn't mean that if you've got it through a confidential means, such as a relationship with the bank or your doctor or your lawyer or something else, and you've got that information, just because it's in the public domain, it doesn't mean that you, the data controller, can share that information with somebody else. Because just because it might be accessible elsewhere, it doesn't mean you can use the fact that you have that information and share it with somebody else. That's why, as far as GDPR is concerned, whether it's collecting or sharing, processing, storing, etc., information that is in quote-unquote the public domain is not fair game. That's not how it works. Going on in this statement, she says, "I was not part of the decision-making process to exit Mr. Farage." Pausing for thought there, if she was going to say anything at all, then it should have been with full knowledge and obviously with consent and everything else. But aside from consent or a legitimate basis for doing so, if saying anything at all, it should at the very least have been 100% informed and accurate. Not that that means that she could have shared it. She shouldn't have shared that information regardless. But if she did, it should at the very least have been accurate. This decision was made by Coutts, and I was informed in April that this was for commercial reasons. At the time of my conversations with Mr. Jack, I was not in receipt of the contents of the Coutts Wealth Reputational Risk Committee materials subsequently released by Mr. Farage. I have apologized to Mr. Farage for the deeply inappropriate language contained in those papers, and the board has commissioned a full independent review into the decision and process to ensure that this cannot happen again. Well, that sentence is almost contradictory in that it says that the board's commissioned a full independent review into the decision, which suggests that they might be looking at the decision to reverse the decision, but then to ensure that this cannot happen again. So is it one, the other, or both? Is it a review to the decision to potentially overturn it, a review of the decision to make sure it doesn't happen again, or both of those? I'm not quite sure from reading that. Put simply, she said, "I was wrong to respond to any question raised by the BBC about this case." On my reading of that, insofar as any potential claim for anybody in a situation like this, not that anything I ever say on this channel can be taken as legal advice, but that, in my view, is a clear admission that she had responded to a question raised by the BBC about this case, about Mr. Farage's accounts, when she should not have done so. I want to extend my sincere apologies to Mr. Farage for the personal hurt this has caused him, and I have written here to him today. But that, of course, is not necessarily going to be it for Mr. Farage. I certainly wouldn't blame him for continuing this campaign, as he calls it, to revolutionize, I suppose, the banking industry, because I have spoken many times about this now, that I have seen firsthand with clients how this can affect individuals that don't have the clout and the reach that Nigel Farage does. And they have simply been forgotten, with even lawyers in my position unable to do anything to help them because the banks simply ignore it. Now that I've grown this channel, I might have some reach to do just that, which is why I'm making these videos, because this is one of those rare situations where I'm going to say what I think. And what I think is, I support Nigel Farage in his efforts to hold the bank to account and to try to reform this, because at the moment, as it stands, he still said in the last video that I just watched, he's up to 10 banks, I think now, where they've just refused him an account, all potentially on the basis of similar reasons. And that just simply cannot be right, just because they disagree with his views, or even just because he has a certain risk of being politically exposed. He still needs to have an account to function properly in this country, as does anybody else. And like I've mentioned several times, this client of mine that was accused of being involved in some wrongdoing, and just because the bank couldn't prove that they were not involved in it, they closed the account, and that was it. They couldn't get an account anywhere else. And so they essentially became a non-person at that point, insofar as operating their life. And so there, quite simply, there are several options that Nigel Farage can consider for legal claims. I will assume that he's taking or has already taken legal advice as such, and I would expect to see some news of the same. So in the meantime, remember to check out The Art of Law in the description below. Check out Black Belt Secrets linked below for my personal thoughts on any of this. And as always, thank you for watching.